I'm a clinical professor of law at Duke Law School. And I am so excited to welcome you to our Teaching Justice webinar series. Today's session, we are thrilled to have with us Sarah Lorr from Brooklyn Law School, who will be leading us in teaching disability justice today.
Hi, everyone. I'm Layla Halas. I'm a clinical professor of law at Tulane Law School, and I'm a member of CLIA's Best Practices in Pedagogy Committee, along with Allison, and this series is a part of that, or is a project of that committee, where we try to feature innovative faculty who are thinking about new approaches to teaching justice and how that intersects with current social movements and topics in today's realm. And so we invite you to join us. We have one more session coming up, and we will be continuing next year. So please stay tuned to the CLIA website and all the listservs to figure out how to watch the recordings and how to register.
And we always encourage a lot of interaction, especially using the chat function during the presentation. If you have a burning question or you need some clarification, please feel free to throw that up into the chat. Layla and I will be monitoring. And then we'll also try and make time toward the end for more focused interactive questions with our presenter. We do invite you, if you're comfortable, to keep your video screens on, but by no means is it necessary. But do ask that everyone please mute themselves if they haven't already for the pendency of the presentation. You probably saw already that this is going to be recorded, and as Layla mentioned, we will share over the all of the listservs, Clinic, Lexturn, all of the above, the ways in which you can access that recording, but know that we always keep this one and all of the past recordings on the CLIA website. So with that, I am going to hand it over to our amazing presenter, Sarah Lorr. Thank you so much for joining us. And yeah, please take it away.
All right. Thank you so much, Allison and Layla, for having me. It's really like a true honor to be here and to share my ideas about how to approach disability and ableism, which are basically in constant evolution, but through the clinical practice of law, sort of how we can use clinical practice and our work as lawyers to push back against ableism. So I'm going to share my screen. So give me a second for that. And then let's see. Okay. Hopefully we can all see it. Great. So my cover slide, I'll just describe. Oh, first, let me give a sort of a description of myself. I'm a white woman with glasses and dark brown hair and bangs. I'm wearing a black shirt, a black blazer, a green necklace, and I'm in my office. And my cover slide has a picture of 3 different women, different shades of brown. There's a sort of a longer picture description on the slide, but one woman is on a ventilator. She's a darker woman with an afro wearing an orange shirt, woman with slightly lighter brown with short blue stripe in her hair, short hair, and a green shirt, and then a woman holding a white cane with longer brown hair and bangs. So back to me. So my name is Sarah Lorr, and for many years I worked as an attorney representing parents in the family regulation system, which you've probably also heard of as family policing or the child welfare system. And then I spent 4 years as the co-director of the Disability and Civil Rights Law Clinic. And so this sort of, the work I did there was really unique. It's conceived of as a general clinic to support the needs of adults with intellectual and developmental disabilities. But my work really continued to focus on the representation of parents with disabilities in family policing and guardianship cases. So now I just say, to shorthand, that sort of Britney Spears cases, folks who do not believe that they need to be under guardianship, but where there is a person in their life who has taken on that authority, or an organization. So as a scholar, I've sort of spent a lot of time assessing the failure of family and federal courts to apply the Americans with Disabilities Act to family regulation, and in response, asked how we could use disability justice principles to kind of push back against those failures in family court, and looked at how the family regulation system, more recently, I've looked at how the family regulation system produces disability. But then this past year, I taught torts in federal courts. So I guess I want to say before jumping in that this presentation has sort of been a gift, and that it's let me think about and reflect on the connections between my scholarly work and my work representing parents with disabilities and my clinical practice. And in many ways, I think my scholarship is a direct result of trying to bring these theories into my practice and observing the ways I've either failed to do that or could do that better, or where I see generally kind of room to improve across clinical practices. And so it's kind of in that spirit that I offer these ideas. And kind of one more kind of caveat almost before we begin, I guess I want to acknowledge the title of my presentation, which is Teaching Disability Justice. It's ambitious beyond what I will sort of realistically accomplish today. It's sort of, I think it's better to think about it as kind of an introduction to disability justice in the clinical context. It's especially important for me to point that out, I think, just because of the inherent tension between my role as an academic and a practicing lawyer and the true disability justice movement. Disability justice was conceived by disabled queer activists of color who, when they looked at the progressive and radical movements that they were working within, saw that those movements had failed to address ableism in their politics. So from there, these activists developed frameworks in community with each other. So particularly Patty Byrne, Mia Mingus, Leroy Moore, Stacey Milburn, Eli Clare, and Sebastian Margaret. And so it's especially important to me to be clear that disability justice centers the leadership of the most impacted, and that we sort of, they are very clear in their manifest principles that we should not, quote, look to academics or experts to tell us what's what. We are lifting up, listening to, reading, following, and highlighting the perspectives of those who are most impacted by the systems we fight against. So that's part of why I amend my title to be sort of more an introduction to disability justice in the clinical context. Or another, maybe more succinct way of describing this is sort of just my ideas about countering ableism through clinical practice and pedagogy. And the other reason I wanted to sort of pause there is to acknowledge that this and thank this rich lineage of scholars and activists who come before me, especially those who initially developed the framework and who continue to develop it. And most especially my former co-director, Priyanka Nair, who her work and ideas is imbued in so much of this, and sort of comes with me wherever I go. So that was a lot of entry chatter. So thanks for bearing with me. The first thing I'm hoping we could do is just take a quick poll so that I have a sense kind of who I'm talking to, and that you have a sense of who's in the room also. So I'm interested in, like, what kind of clinic do you run? So if you could just take this poll, hopefully it's easily accessible, but let me know if you have any trouble. And then I have a couple other polls and then a short brainstorming. Don't worry, it doesn't involve any talking to each other. Project that I want us to kind of do together. Awesome. So it's like a really, I'm so curious. The other is getting bigger and bigger. It was very hard to come up with what to represent. So I'm very curious what's represented in the other. But okay, really interesting. Maybe I'll give it, since results are still coming in, I'll give it one other second. Other. Okay. All right. So kind of building on this and with this in mind, do you conceive of yourself as serving clients with disabilities in your clinic? Sort of consciously and directly, and this is an awkward, there's many sort of shades of how you might think about this, but one thing I spend a lot of time talking to my students about is just this idea that we are a disability rights clinic, but that doesn't mean very much. It means people who with disabilities are just people with different legal issues. And so sometimes it means we are more likely to work in one area of the law or another. But often it's such a broad, it's sort of a misunderstanding. and leads to, I think, to lots of folks thinking we just do benefits law, which is part of why I want to ask this question. And I'm so glad that no one says no, not consciously, because I think it reflects a general understanding that your client populations are probably quite rich and diverse, regardless of what you do with them. Okay, well, thank you for sort of humoring me and also for giving us this chance to start. And the last kind of activity I have for us is one that it's an opening brainstorm that Priyanka and I have used in our clinic in the past, usually on the first or second day. And I'm hoping we can just sort of create a word cloud together about associations with the word disability or the concept or what you imagine or associate or in your own experience have from the lived experience of disability. And I'm hoping you'll contribute just a few examples or thoughts. It can be from your own associations or from the broader culture, or maybe even more interesting or interesting in a different way, sort of the legal community, which I think has quite complex space for people with disabilities. So just as these come in a little bit, I'll say typically Priyanka and I did this activity verbally with students on the first day of class, and we would use it as an opportunity to talk with some anonymity about the different associations we have and how they might relate to our clients' experience of the world, or how it might impact our relationship with our clients and how we see them or expect them to see us, and their relationship with their own family members. So lots of folks saying misunderstood, barriers, marginalized. I love to see me and many family members, invisible, which shows up twice, so probably should be bigger than it is, diminished, stigmatization, power, creativity. So in our class now, we usually talk a lot about these associations and how even those sort of kindly held often reflect ableism or negative cultural attitudes about people with disabilities. So in our class, and some of these are similar to those that show up, but they often reflect kind of pity or sympathy. Anxiety about accommodations is like a big theme in the law school context. I don't know if you experience that. Sort of the veracity of the claim of disability, the propensity that it might be misused, which Duran Dorfman has written about, calling it the fear of the disability con, and sort of other remnants or reflections of bias and discrimination. And in our class, as a group, we kind of consider these associations and biases from all angles. And usually we really take our time with this assignment. Like it could be a full half hour of just like talking about these themes and associations. I think our agenda today is somewhat different than an early clinic class. So I'm going to move us on to talking about some of the key concepts that underpin my work and that I've already referenced. But I think it is kind of a good place to start, even a conversation like this, just because it gives us a sense of kind of the weight of the word itself and like how much it carries and how even on this, in this quick exercise, like somebody wrote superpowers and other people wrote invisible, which could be a superpower, I guess, but I think probably not how it's meant here, you know, and versus marginalized and less able. So I think even here you see these like vastly different conceptions of the concept. All right, so I love this definition from T.L. Lewis. It's a definition that T.L. developed in community with disabled Black and other negatively racialized people, especially Dustin Gibson. And T.L. tells us, I think importantly, that ableism is a system that places values on people's bodies and minds based on societally constructed ideas of normality, intelligence, excellence, desirability, and productivity. These constructed ideas are deeply rooted in anti-Blackness, eugenics, misogyny, colonialism, imperialism, and capitalism. This form of systemic oppression leads to people and societies determining who is valuable and worthy based on a person's language, appearance, religion, and/or their ability to satisfactorily reproduce, excel, and behave. You do not have to be disabled to experience ableism. This is sort of a grounding definition for me in my work and also in our clinic. And we introduce it very early on. And I'll sort of add to it a working definition from Patty Byrne, another activist who says, We cannot comprehend ableism without grasping its interrelations with heteropatriarchy, white supremacy, colonialism, and capitalism, each system co-creating an ideal body mind built upon the exclusion and elimination of a subjugated other from whom profits and status are extracted. And the definition goes on, but she talks about how able-bodied normativity sort of creates this white gender normative body mind that is then used to create anything that varies from that is labeled deviant, unproductive, or invalid. And I think these are such important places to start in any conversation about disability, but especially in a law school classroom, because we are regulating behavior. So much of what we do, and especially in a family defense clinic, talking about a very norms-driven area of law, is about sort of how we define norms and what we expect, and what does deviance mean, and what is somebody who's unfit to parent. So from these definitions, which I engaged pretty directly on day 1 or 2, we begin as a class, and you can begin to see how ableism as a concept can kind of act as a lens to expose new and different ways of understanding legal standards, and even the attorney-client relationship and the law itself. So continuing on sort of this theme of the kind of making sure we have these working concepts, this slide just has the 10 principles of disability justice. And I'm not going to walk through all of them or highlight all of them, although I really do suggest spending time with them. And the rest of my presentation will kind of connect back to many of them, even those I don't highlight. I did want to kind of linger on the first 2 and then number 5, and talk about how I address them in my clinical work, and then kind of we'll connect back. So the first is intersectionality. And I hope and I imagine that we all engage this concept in different ways in our work, but I find it to be particularly powerful and kind of to go beyond that which our students come in ready to understand in the context of disability. So it's not on the slide actually, but Mia Mingus, another activist, has observed that ableism is connected to all of our struggles because it undergirds notions of whose bodies are considered valuable, desirable, and disposable. So it's, certainly on the same theme. But the first principle of disability justice really has the effect of describing how disability, race, and other identities are used together to render many minds and bodies invalid. And what I think is so important about it in the disability context is that it draws attention to the way disability can be socially constructed or put together basically by outside forces. I'm going to talk about that more on the next slide, but I sort of wanted to draw our attention to it here. And I think it also pushes us as advocates to see individual clients and their full and entire context, something else I'm going to talk a little bit more about in detail once I'm kind of done with this introductory section. So the second concept I wanted to draw to our attention is the leadership of the most impacted. And I sort of alluded to this and I spoke briefly about it at the beginning. And I'll be brief about it here, but it's something else that we'll come back to. And it's a principle that really guides how I teach. And you can already see this presentation is like as much other people's language as it is mine, in part because I think that is just so significant. And the power of using the words of folks who are most impacted and have lived experience rather than describing their words, sanitizing them and putting them into a legal framework, I think is almost speaks for itself. But I will talk more about how I do that intentionally in class. And then finally, I wanted to talk about 5, recognizing wholeness, because I think it calls upon us to recognize that disabled people are whole people with internal experiences. And this is actually coming from Sin's Invalid, that their thoughts, their sensations, emotions, sexual fantasies, perceptions, and quirks. And I think that definition kind of functions as both an admonition and a reminder to treat our clients, especially those with disabilities, and their families as whole, complex beings with perspectives that are unique from our own, and also to see their full and complete humanity outside of the confines of the specific legal conflict or system in which they're enmeshed. And I will talk more about ways I think that can be sort of sewn into advocacy and how we've done that in the clinic. So before getting into all that I'll talk more about, which is coming, I promise, I do want to kind of introduce the concept of disability as a social construction. So I've alluded to it a little bit, but I want to make sure we all have kind of a working knowledge of it, because I think it exposes so much about how the law functions in the lives of people with disabilities, and frankly, how the law functions in the lives of those who are marginalized and disadvantaged, and how disability can be used as a screen for negative treatment and pathology. So while disability can be a legal concept that's defined by specific laws and statutes, and a medical concept defined by impairments or diagnostic criteria and symptoms, I want to focus on social construction, because I think it is this concept that can be so destructive to many of my clients' lives and those ensnared in sort of many of the poverty law systems. So just as critical race theory has argued that race is a social construct, there's a line of critical disability theory that argues disability can be the result of external conditions or social construction. One popular understanding of social construction, which you have probably heard about, is the idea that disability is created by an external environment. So a person who uses a wheelchair is not disabled by their mobility impairment, but instead it's a lack of ramps or elevators. In fact, I think this oversimplified view risks obscuring the role of impairment and pain in disability, or the reality that people with disabilities do face limitations or biological realities, or at least that they may face those as the result of their disability. But even with that caveat, I think the social conception of disability is such a significant concept, especially in family regulation or criminal legal systems, poverty law, educational law, basically anywhere I think that individual rights are at stake, because it helps us to understand a few things about the disability label, right? It helps us to see that perhaps why people with certain observable characteristics are more likely to be identified as having a disability, right? And that's something that's borne out in social science research. Whether or not they meet a legal or medical definition, they are just more likely to be seen and identified that way. It also helps expose that some people are labeled as having a disability regardless of whether they're actually impaired or understand themselves as having an impairment. So this category is especially important in family regulation cases where caseworkers or others can just sort of like readily identify a parent as having a disability without evidence of a diagnosis or impairment, and a judgment is made and it gets written down and sort of in a snap, and it gets repeated from document to document, and judges quote it as if it's fact. And so it's just really important to kind of understand the way in which it is this flexible, malleable label that can be used and invoked based on external factors. I think the social lens kind of also reveals the many ways we see, or helps us pay attention to, the way disability can surface in family court in so many ways. So it can be a precursor to involvement. It can be like a basis for the reason somebody is in the system. It could be the only fact on the petition that this is a mother or a parent with a disability. It can be a reason for family separation. It can be also a compounding consequence of the system, right? The trauma, the PTSD, the actual experience of family separation, or going to court day in and day out. So these are all sorts of reasons that I attend to, and in the clinic, we really spend time on this idea of the social construct of disability. So I'm gonna shift gears just a little bit here to talk about sort of like how I think about this in clinical practice. We have now kind of this theoretical background, and I just wanted to give some sort of more concrete ideas. Of course, this will depend on your cases and practice, but I contend that in almost any practice, you can be working with a disability lens, and probably should be. I'm going to mostly discuss it in the context of family defense, where I focus my representation, but I think this is work that could be done even outside of a disability clinic and outside of a family defense context. So you can think of this as scaffolding also, but similar to today, I always start with discussions of disability justice and ableism. I identify law school that as a historically white, able-bodied place. and the fact that the law has sort of enshrined this white, able-bodied person as the norm from which all others deviate. And I think beginning our relationship as a class together and in that way gives us so much space from there on to interrogate that more deeply. And so that's just sort of basic, but I think where you begin is so important. I think probably also kind of not new to most of us here is the power and effect of language and how much meaning and viewpoint and value it can reflect. But in the clinic, we spend a significant amount of time openly discussing kind of the promise and peril of language. And I think it's so important in a disability context, because many people, even those with disabilities, are afraid to talk about the word disability, and are afraid to use it the wrong way, afraid to misidentify, afraid to identify someone who didn't want to be identified. It can feel, because of the way, in many ways, it's stigmatized, very fraught. And so we talk about sort of and name up front both that it can be scary, that you will probably get it wrong sometimes, and that it is really important to try to get it right. So we talk about how first-person language is kind of the preferential way, so that you're communicating about somebody who is a person who has a disability as opposed to a paraplegic person. So a person with paraplegia. But we also talk about the fact that there are many members of the community who embrace identity first language, who want to be called deaf and proudly identify that way, or proudly identify as part of the autistic community. We talk a lot about avoiding euphemisms like special or differently abled, and boy, is that a habit that dies hard in my experience. And it's sort of premised on the idea, I think we use those labels because there's the sense that maybe disability itself is a dirty word. And they're problematic, especially as lawyers, right? They're unclear, they're not accurate, they don't really express meaning. And so we spend a lot of time talking about being clear. And we also talk about sort of avoiding negative words that imply sympathy or pity. So aiming for sort of neutral language, like Tim has diabetes versus Tim suffers from diabetes, or is wheelchair bound, etc. So I started us off talking about intersectionality just because of its role in the disability justice framework, but it's really quite central to how we think about the clinic, and how we talk to our students and help our students to understand our clients and vice versa. And so hopefully we're pushing beyond kind of what students already bring and helping them to think about their clients' relationship to power because of their intersectional identities, and also their relationship to power and their clients' relationship to disability, and vice versa. And here, really guided by this, the Disability Justice Primer, Skin, Tooth, and Bone, which talks about sort of the grateful embrace that we can have of the nuance that this principle of intersectionality brings to our lived experience and the ways it shapes the perspectives we offer. And in my thinking and in my clinical teaching, this has a direct line to client representation. It encourages us to see and support our clients with the nuance that they bring, and also that we too are shaped by our own perspectives. And part of that means kind of pushing students to imagine what might happen if all of the actors in the family regulation system were able to kind of access and respect and appreciate the multiple identities of our clients. Because to the extent the family regulation instead kind of zeroes in on one particular aspect of a person's identity and punishes it, or otherizes it to an extreme, we as a clinic seek to interrogate that, and to begin to imagine alternative ways of supporting the parent or person in their kind of full complexity. And by doing that within the clinic, we are also then kind of guaranteeing that as part of our advocacy, we'll be pushing quite consciously that other system actors do that as well. And I think at its best, that means our client representation is a means of actually creating a system that does respond to support needs by advocating for genuine, full-throated support for our clients, and often winning those motions because they are underpinned in the law. It doesn't happen in every case, but that we can try to be really creating the system that we think would be more responsive, while at the same time engaging in full-throated critique, I think it's fair to say, of the system as it exists. But really trying to allow the courts really to see the parents we represent as individuals who are surviving and striving to raise a family in a society that has fundamentally failed to support them, not merely as individuals who are sort of trapped by personal failings or individual errors. So we spent a lot of time centering lived experience. So in my work representing parents and family regulation, this can mean consulting, always paid consulting, strategizing, being directed by people with lived experience. And it depends on the case what that means. So for a parent seeking reunification in an individual client case, we're really going to focus on that person and their expertise, and what they know about what they need to be a parent and what they need about their disability, however they refer to it. And it may or may not be that what they need is disability related. But it also means including readings by parents with disabilities, bringing and paying lived experts to the classroom. Natalie Chin started this wonderful practice that we continued in our clinic, where we bring folks who are self-advocates with intellectual and developmental disability into our classroom to do an interview activity. So instead of bringing actors, we bring folks with disability to do the interviews with our students, and they are part of quite consciously educating our students about how to interact with people with disabilities in a respectful way in a legal context. And that has led to so many different really generative conversations over the years. We've also invited folks just to come and share their movement advocacy and educate the classroom on their own experiences. In policy projects, it can mean kind of co-planning with people from impacted communities. I helped start, but I'm no longer involved in, this amazing doula project that the clinic is doing, where we have a whole executive board of adults with disabilities who have had their children removed in child welfare proceedings, who are talking about what it is they would have needed at their birth and what it would mean to have a doula in the room. Certainly writing with folks with disabilities, centering them on panels. These are all ways that we try in the clinic and that I try as a scholar to really live that. Cross movement and cross disability advocacy is, they're both separate principles of disability justice that I didn't really get to discuss, but we spend a lot of time encouraging students to find and identify overlapping movement goals and create connections between existing civil rights movements. So we're in a moment, for example, in New York City, where we've really returned to using the criminal system to control mental illness in a really overt way. Under Mayor Adams' plan to involuntarily remove those who are suffering from mental illness in public places and who appear to be in danger due to their inability to meet their needs. This is like a really open moment where mental health advocacy and criminal justice advocacy have sort of come together. But it's necessarily cross movement, right? It involves folks who advocate on behalf of the unhoused, folks who advocate on behalf of the disabled, folks who are part of the MAD movement, who are anti-psychiatry, folks who are prison abolitionists. And so it's just necessarily cross movement. And there are these like incredible moments where you see major systemic change happen. But there are, of course, almost too many other examples to count of how sort of punishment and therapy or punishment and care have been entangled in our legal system. So really just spending time encouraging our students to find those moments and then to dig into those moments. The last thing I think I want to highlight here is just the need to interrogate and identify the way ableism shows up in cases, or said in a sort of more disability and critical race theory way, being alert to the ways that race and ability are socially constructed, and the fact that that will have material and psychological impacts on the person, right, who is being labeled that way. And so being conscious about that when you advocate. So I think this maybe is not, I wouldn't say it's only of sole importance to family court, but maybe particularly so because of this norm-based area of law, but where non-compliance is often coded racist, ableist language, right? The idea that someone's not taking care of their mental health, they're not complying with court orders. These become sort of subjective standards that become a vessel for these much more obviously wrong judgments that are sort of racist and ableist. And similarly, best interests and risk and all these terms can become really coded. And so we talk a lot in class about how to sort of identify that in the law, and then also what to do in response to that, right? There are often times, and I think just for the sake of time, maybe I'll skip ahead a little bit, where to the bottom of this slide where I talk about advocating with ableism and social constructs in mind. You know, often parents or attorneys have to make strategic decisions, right? And we decide, are we gonna take a conscious approach to disability in this case? Are we gonna use, so are we gonna center disability? Is that something our client will want to do? Is it safe for them to do that? Or are we gonna use ableist metaphors and we're going to sort of rely on ableist tropes because we think that's the safest way to get the judge to do the thing we want to do? And I think some areas of law, benefits law, often advocacy under the ADA, fights against prison confinement, they can seem to require ableist advocacy. And I think we have to think about that. Are those decisions we want to make? And if so, why? All decisions, of course, you want to make with your client, but also you want to make them kind of with the awareness of the trade-off. And to acknowledge that you might be sort of reifying ableist frames. In family court, we spend a lot of time thinking about, like, is this a client who should identify and seek services for their disability, or would it be better for them in some way to pass or hide to avoid confronting that bias? And then how do we grapple with that? What does that mean? And to what extent is that us sort of upholding notions of normalcy within the system? Because when you make a strategic decision like that to hide a parent's disability, to avoid trigger a greater concern, you also have that paradoxical effect of hiding the way that parent might be functioning in a really beautiful interdependent web with their neighbors and families, and this opportunity to showcase that kind of strength. So that's sort of one place. There's a few other ways that I think I'd rather sort of us interact than we go on and on. But I do think most of these, what I have here on this slide, disability justice and clinical practice, apply to all clinical practice, but in a special way when you're consciously, or specific way when you're consciously thinking about disability. So for example, where I have trauma-informed lawyering, the population that of adults with disabilities that I work with is much more likely to have faced forced institutionalization, violence during that experience, violence in their childhood, in their public schools, they're just much higher rates. So really being attuned to that, I think presenting, sort of going up the slide instead of down, thinking about how client relationships and really considering support networks and interdependence can be pivotal to legal representation. So where clients rely on friends, family, or staff for support, thinking about how you can ethically include those people in your conversations. Some folks rely on formal supported decision-making agreements to avoid guardianship. Other folks have, and much more likely, are to have informal decision-making networks, but they still need those folks, or at the very least, want them. And I think often ethics rules can be interpreted to include a client's extended network. So it's a question of how you do that work and whether or not you can sort of, how you can work to really honor your client's interdependence and their multiple support needs, while obviously ensuring the security of the attorney-client relationship. So I think I'll end with just sort of the overall goals in my pedagogy and practice in broad terms, can be talked about as sort of centering disability as a positive or neutral identity. And that's not to paper over, again, the kind of pain or biological difference that can exist for folks with disabilities, but to shed light on the complex lived reality and humanity of folks who are labeled disabled. So there are a few ways I strive to do that in my practice, and one is really by looking at parents who have used their own voice in court and trying to find ways for our clients to use their own voices in court and really amplifying their stories, their narratives, their experiences often, and finding ways, if they want, to actually directly speak to courts. The second is really trying consciously to build cross-movement coalitions outside of court. So in the family regulation context, there are like growing, and there have been for decades, but I think they're more powerful now than they have been, parent advocacy movements to repeal CAPTA or the Parent Legislative Action Network that are really working to change national and local laws and family regulation, but they are not deeply connected to the disabled parents that I work with. And so finding ways to bring those families to that movement and bring the movement to those families, because the overlaps are much, much bigger than I think folks understand, going back to that kind of intersectionality point and the idea that many, many people are being labeled as having a disability who might not otherwise self-identify. And then finally, really centering disability and interdependence in our litigation. So here I try to build on sort of feminist disability scholars and more contemporary disability justice activists like the ones I mentioned today, to have urged this kind of reframing at a cultural level, but also to bring that as a lawyer and as a clinician into litigation, right? So helping our clients tell these stories about their lives, about who actually supports them. What does interdependence look like for them? So where the judge is seeing them as sort of broken or unable or incapable, how do they get through the day? Who are the people who help them take care of their children or who enable? What are the techniques they have, the tools they use, so that they can actually either demand the tailored and specialized services that they need, force the creation of new services, or show how they're doing it now, and why it benefits their children to stay with them. So I think on that note, it would be great to sort of talk, if any of this resonates, about your own practice or feels impossible in your own practice. A lot of the times I think about these ideas, I think about like how angry I would have been as a public defender. And that's like my gauge for whether I'm thinking about reasonable change or unreasonable change. Like I want to be dreaming about change, and also I want to live in reality. And I think that's a kind of a unique clinical space that we all understand, but I'm interested in responses and if and how you grapple with this in your own case work.
Thank you so much, Sarah. Want to open it up to anyone who has a question or comment or theme that they would like to raise in conversation with our presenter. Feel free to just unmute yourselves, or you can raise your hand, or if you'd rather, you can throw a question into the chat.
I might kick us off, Sarah, when you were talking about some of the readings that you assign and making sure that you're centering like the voices of kind of like directly impacted folks and have those voices. I was curious if there were particular pieces or like foundational ones that you might want to share with us.
Yeah, I love that question, and some of them are cited in the presentation. So I think Patty Burns' working definition of disability justice, which is just a blog post that's very available. One of the great things about disability justice as a movement is how accessible it is. It's obviously by design and not an accident. But this is a community that has been online much more than most of us until the pandemic, because many of them are advocating from beds and hospital rooms. But so Patty Burns' working draft is amazing, and really, really rich, because it's also it's like both poetic and sort of in plain language. So I think students really enjoy reading that. I have with me Skin, Tooth, and Bone, which is called, it says the basis of movement is our people. This is sort of like what they call the disability justice primer that Sins Invalid has written and published. And I have assigned from that, although less frequently. I often assign reflective essays from folks. There's a great piece from the Sun magazine from mid-2000s, like 2010s maybe, I guess I mean, that is a mother reflecting on the use of the R word about her child, that I think is not nearly as like radical, quote unquote, as some of the other pieces, but that for many of our students who haven't thought super critically about disability, but have family members who have disability, or who are interested in it. It gives them kind of like a natural way in. And then for the folks who are like really theoretically engaged, there's a disability critical race theory essay that sort of is the founding principles of a lot of these ideas that comes out of educational research that I think is also excellent. And I'd be happy to share any of these things.
Hi, Sarah. This is Suzanne. I just wanted to say thank you for pointing out just the whole disability justice perspective, because sometimes I find that talking about intersectionality, but from the perspective, as you pointed out, Audre Lorde, and also originally from Kimberly Crenshaw, is sometimes challenging, you know, across campus and across disciplines. So I really did appreciate that, as well as you pointing out, you know, in terms of our representation of our clients. Do we acknowledge the disability? Do we not? And I often find that that's also sometimes the choice of the client.
Yes.
And I can engage in that strategic conversation with the client. But and as litigators, we sometimes will want to present certain information so that we can control how it's received. But given that this is an identity that belongs to perhaps, well, that belongs to someone other than us, I think it's important to engage in that conversation. And I remember happily an instance where, you know, we did that knowing that the other side was going to bring it up, and it was a custody matter. And, you know, our client's case was presented without naming the disability, which was very visible. But we did not want her to be defined in that way. And just made the decision together with her that we would not do that, but we're prepared when the other side raised it. So thank you for that as well, and great to see you.
Yeah, so nice to see you. And, you know, I love hearing your thoughts about this in particular, because I know we do such similar work. But obviously from slightly different, you know, on behalf of our own set of clients. But yes, I mean, hopefully not lost in the presentation is the idea that this is completely client-centered. I mean, one of the things that's so powerful, I think, about disability justice as a framework is how, as a lawyer, is how readily it maps onto so many of the things that I think at least clinicians are so geared towards. And each time, even as I sort of push towards amplifying just the idea of disability as a positive or something that's certainly not to shy away from, it's just as important to acknowledge the hundreds and hundreds of cases I've had where it has not been strategically sound for a client to do that, or they just haven't wanted to. And most of the time, especially if I'm presenting to certain non-academics and maybe not even defenders, but folks who engage in this work and are thinking about disability and trying to push them to think about this, a lot of what I talk about is just don't be afraid of it. Just talk about it. Because if you don't talk about it, you will miss this opportunity potentially to use laws that would benefit you, to engage arguments that would benefit you. But also you sort of are sort of reproducing this idea that it's something you can't talk about. So yeah, having the conversation is the most important thing, and then following kind of your client's lead for sure.
Yeah. Well, thank you for that additional piece. We also talked about it as a genuine asset.
Yes, yes.
In the parenting. And honestly, it was wonderful learning ground for the students and for myself. So.
Yeah, I think I see Steve's hand.
Hi, Sarah. Sorry, my internet went out. I'm gonna try this. And maybe I missed something that Suzette said. And wow, I just have to say, I'm so impressed with the level to which you've taken this discussion. I want to thank Allison and Lila as well for focusing on this subject. I've taught disability law, disability rights law at the law school and undergrad level and find the concept of disability justice difficult to teach, and also to put it in a clinical setting, in a practical setting. Your slides are wonderful. All the nuance that's there, you know, talking again about the importance of integrating this concept beyond disability classes. It's just wonderful. And it's kind of, I would call it like, you know, like the third phase of feminism. This is like the second phase of teaching disability law in both a clinical or a law setting, and just really want to applaud what you're doing and look forward to seeing more of your materials and trying to integrate them. So thanks to y'all for doing this.
Wow, that's awesome, Steve. Thanks. I'd love to see how you're doing it now and like think about it. I think one of the things that's changed for this sort of wave, as you refer to us, is how many of us have disabilities, how many of our students have disabilities. You know, many of us, if we weren't, I was not born after the ADA, not close, but I came of age with the ADA. And I think it is just like, as much as you can understand, and many people do understand, and I do, I think conceive of disability justice as a critique of disability rights, it is also a huge mistake to, I mean, it exists in many ways because of the movement, or at least alongside the movement. And I certainly feel like we can really, because of the ADA, we can do a lot of this that we couldn't, and the agitation that led to the ADA, you know, that the movement.
Other questions or comments for Sarah?
I have a question. Hi, this is Yael. Sarah, thank you so much. This was a really, really amazing presentation, and totally echo everything that that Stephen said. I wanted to ask about the sort of inclusive language conversation, and it's so nuanced. And you were talking about how even people who themselves, you know, have disabilities might feel very differently about what language is used and how they identify. Do you have a good reading or podcast or like something that you think captures some of that nuance? And or can you talk a little bit about how you explore that with your students?
So Lydia Brown, who is actually the artist who did my cover slide, which I think somebody really appreciated, so I should credit Lydia, has a great piece that I can put in the chat, or I can find and send, about person first versus identity first language, and why they choose identity first. And so I think that's like a great starting point that I actually might cite it too in a recent article. But a lot of what I do with students, I don't think I've ever assigned a reading about that. I think we talk on day one, and we have a slide of basically like bad examples of what not to say. And the R word isn't on it anymore. It's just says the R word, although I'm sort of truthfully, it used to be. But there are a lot of other words that are basically common parlance, right? Language that we would all use, or that I certainly still lapse on occasion. And we have a conversation about that. And I own that immediately. Like, I make mistakes. And I think on my very first day of teaching this, I in class used one of the phrases that is on the slide that we should all endeavor not to use. And that isn't to make light of it, but I really think it's important that folks feel safe, and that it's not a place where they're going to get judged for getting it wrong. And so a lot of our conversations have been kind of around that, and just making it an approachable conversation, so that the use of the language isn't a reason not to talk about disability, and isn't a reason not to talk about the tricky issues involved in cases. And also to emphasize that the nuance involved is exactly why you have to be able to talk about it, because you have to be able to ask clients how they want to be identified. I have, all the time clients will say like, oh, I'm bad at math, I don't do directions well. Those are not folks necessarily who say I have a learning disability or I have dyslexia. Those are folks who may also identify and may not. And so choosing how to introduce the concept, when to introduce the concept, if to introduce the language, all is going to depend on the person that you're talking to. But without the ability to talk about it openly, it's going to be really hard. So most of what we do, at least at the beginning, is just sort of think about this, but I'll try to find, unless it's already, yeah, I'll try to find the Lydia's piece, and then I think it looks like Steve has something too.
Yeah, I love this. I love this subject. Yeah. It's I think Sarah, the way you put it earlier, very briefly, reasonable people, even unreasonable people, disagree on the terminology. When I worked at Disability Rights California, well, DRC, well, that's it. I won't call them out, but I was religiously person with disabilities, person with disabilities. I say, no, some people like the identity first, the disability first language. And
Yeah.
and I think we need to honor how that's different. And like I say, people disagree. I think Allison, you years ago wrote a piece about crazy, if I'm not mistaken. You had crazy in the title. If I got that right, or am I mistaking? I think you wrote employment law. Anyway, that's again another term that even referring to an inanimate situation. This is crazy. Where I worked, it was like, no, verboten. So it's a good thing to bring up. I'll say one last thing. And I said, if people want to write me, I've got some reading. A guy named Jim, I want to say Jim Sinclair, wrote back in the Stone Age, like 1970s, about autism. He said, I'm not a person with autism. A person with autism like a person with a yellow shirt, or today I'm wearing a purple shirt. I'm autistic. And that's another case of where we've kind of come around, not to mention, neurodiverse and so forth. So I think it's a great topic to discuss and to put out there that there's all kinds of things on the map. Anyway.
Yeah, and this is another opportunity, I think, Yael, to use writing and thinking by people with disabilities. There's some great interview clips, also sort of from the Stone Age, as Steve says, of people who did the sit-ins talking about their own relationship to their identity. And it's super powerful that it's not folks who are insisting on person first language. They're just talking about their lives and who they are. And anyway, I do not have on hand because it's kind of all over the internet and hidden places. But if I find that, I can send it your way.
And Sarah, where did you get the list of terms to avoid?
Oh, created it.
Uh-huh.
My former Amy Mulzer, who was at the clinic years before, had started a list, and then we've just added to it over time. Yes. I don't know if it's still in regular use. Like, I actually don't think we used it our last year because we came up with other ways of doing it. But I actually found the slide like super powerful, just because it gives people a sense of, without having to say it, without having to talk about it, just like how ubiquitous this language is. And also just the inevitability also of error, which I think is really helpful. even though we also talk about why obviously intent isn't everything and action ultimately matters more, but intent's also not nothing. And so that conversation sort of is one and the same.
So it looks like we're about at time, but I want to thank you again, Sarah, for such an enriching and exciting and thoughtful presentation. You've given us so much to think about and apply in our own lives, our own clinics. So thank you so much for your presentation and your time. And thanks to everybody who joined us today. Really benefited from everybody in the room being in conversation with us and with Sarah. Please do stay tuned for our next week is our last presentation of the 2023-2024 school year around early family defense. And Layla and I will be posting that on the listservs very, very shortly. So hope to see you all then. Have a good rest of your week.